Viewers, welcome back to the show. Before the break, we were talking about a number of articles, but the last one was about psychiatric patients. I had an example, guys, where a client of ours was in a psychiatric unit in Carlton. The mother left him there. After an hour, she got a phone call to say, do you know where your son is? She was frantic. Before you know it, he'd taken a tram down to the Balti Bridge, jumped off. Luckily for him, unlike these other people in this article, he did survive, but he's got horrific injuries. That case was just settled out of court.
Now, Tony, the liability is on the institution.
Yes.
For not letting him leave.
He could just walk out and there was no one monitoring him and it wasn't properly secured. It's just really extraordinary. Viewers, tonight's topic of conversation is I've got two people that do work cover and TAC. I'm going to ask them, if you're injured, what would you do to lodge a claim for lump sum damages? Now, I'm going to go to John first. John's an expert, accredited specialist in compensation. Now, he's a work cover lawyer. John, if I came to you and said, look, I was injured at work, I've sustained injuries to my neck and back, what would you do to get me off the system or to get me compensated so I can get on with my life?
Tony, there are entitlements that any worker in Victoria that has been injured in the course of work, you're entitled to sue, you're entitled to claim. Firstly, weekly payments of compensation, medical expenses, and they're two no-fault benefits.
That's a common thing, but I want to know, how do you get me off the system? Because I want to get on with my life. I've got these injuries.
And then you've got lump sum compensation. Compensation for common law damages. Basically, that you receive a big lump sum compensation for the work injuries you've sustained, and then you move on with your life.
Well, let me put it to you this way. I've heard a lot of people come up to me and say, look, I've had to wait 4 or 5 or 6 years to lodge a claim. If I came to you, would I have to wait that long?
Rubbish, absolute rubbish.
When would you lodge it?
If that occurs, you should really be having a hard chat with your lawyer. At the 18-month mark, post your work injury date, in Victoria, the lawyer on the worker's behalf can lodge a serious injury application for the worker, starting the process to pursue lump sum compensation.
Okay.
If your lawyer has not lodged a serious injury application post the 18-month mark, you should be asking the hard question, why?
Don, I'll come to you now. Assuming I was in a car accident and I believe I'm seriously injured, and once again, I've heard people say to me, look, I've had to wait 4 or 5, 6 years to get compensation to get out of the system. How long would I have to wait with you to be able to do something to get off the books?
Well, like John said, that's rubbish. You can start pretty much straight away after the accident. The timeline is 3 months before you can lodge an application for serious injury or an impairment benefit, which are available under the TAC scheme. But pretty much, if you come to see, for example, someone like myself, we just get started straight away from the day of the accident, start investigating, get the medical evidence that we need to pursue the claim as quickly as we can.
So on average, when would you lodge a claim for common law damages?
Look, on average, I can do some as soon as 3 months, but on average, you're looking at about 8 to 12 months, depending on each case. It's different.
Well, it's a lot better than the 4 or 5 or 6 years I've been told.
Look, Tony, this is something that you and I come across a lot of the times, don't we, Tony? We come across workers where it's been 4 or 5 years after the work injury, they haven't been able to work ever again, they're suffering serious consequences, and nothing's been done. I just can't believe it. And these people's lives are on hold.
Why wouldn't you lodge a 98C claim for me, John? Because that's what a lot of people are telling me. They say, my lawyer said to me, I'm going to get a small lump sum initially and then I'll apply for the big one. Why won't you go through that process?
The problem with that is, Tony, there's the issue of stability. The work cover insurers can suspend the worker's impairment benefits claim, and that's what we're talking about, the small lump sum benefit, simply due to the fact that the medical condition is not stable, as in you might have surgery in 3 months' time.
Well, just on that point, Don, when do you get stability? Realistically, you're never stable, are you? You're always improving, or you might be going backwards.
Exactly. Well, that's right. It's probably ongoing. Look, some doctors find it very difficult to say a person's stable, but the test is not stability. The test is substantially stable. So if in the foreseeable future the condition is not going to change, and a lot of these conditions you can tell from the outset, the prognosis or prognosis, as long as it's substantially stable, that's when you start ahead and doing everything you need to do to pursue a person's claim.
At the end of the day, you see an injury and you say to yourself, yeah, look, that's serious. It looks serious. I'll lodge it. You'll never be able to predict with any certainty what the person's going to be like in the future, correct?
No, you can't. But at the same time, workers, you have to show that you're suffering serious consequences as a result of your work injuries. I think you and I, Tony, we can assess that, can't we?
Yeah,
we can say, and there are some objective criteria. For example, if a worker is not working because of that work injury, that's a serious injury.
Well, John, if I can't get a straight answer from a lawyer, I'd prefer to be talking to someone that can give me some sort of a more definitive type answer. They can't say with any certainty, yeah, you're going to win this. No. They should be able to give you some guidance.
Experience. And just on John's point, I mean, with the TAC, there's similar schemes with the work cover and the TAC, but on the TAC, you don't have to show a consequence to work. Consequences to pain and suffering and enjoyment of life may be sufficient to get you over the serious injury test, which we'll discuss later on tonight.
Okay, I started this conversation by saying, all right, if I came to you, John, when do you reckon my claim would be finished?
I'm hoping from the date of lodgement, it could be finished as early as 4 or 5 months after lodgement, maybe up to 1 or 2 years.
All right.
It depends on the attitude of work cover, doesn't it, Tony?
And if my claim was rejected, Don, what happens then?
If the claim's rejected, you've got avenues to go to the county court to issue proceedings seeking leave to commence a right to sue, the common law claim. So usually that takes about 8 to 12 months to do. So, you know, with the TAC...
I've heard people say to me that the court system's blown out to up to 12 to 18 months.
It has, Tony. A hearing date in the county court or Supreme Court at the moment, it's a 1 year wait.
Well, 1 year, or is it a bit more than that?
It's a little bit more.
You got to look, lawyers have to be proactive these days, Tony. You got to get onto it straight away and get it moving because we know what the timelines are. We know how long it takes for the matter to get to court, so we have to get onto it straight away.
John, a lot of people have also said to me, no one actually touches base. That is, the defendant lawyers, the plaintiff lawyers. Why wouldn't you get on the phone, try and have a conference with the opposition and compromise a claim?
Oh, if you're a lawyer that is in the personal injury litigation world, you know who the work cover lawyers are. That lawyer should be getting on the front foot and speaking with the work cover lawyers almost immediately. There's nothing wrong with getting on the phone. I hear this story all the time again, that the work cover lawyer for the worker has never spoken with the work cover lawyer. It's unbelievable.
And Don, assuming you make the call and nothing comes of it, at least you've set a path, haven't you?
Well, that's right. I mean, these days, I think the best way to move forward with cases is, well, both parties have to reach the same resolution. There's a resolution of the claim. Why not reach, why not talk, why not make that contact initially to see if you can resolve it without going to court?
Okay, viewers, we've got to go to another break. So stay tuned. After the break, we're going to talk about the most momentous decision to come out of the Court of Appeal in the last 20 years.